Hello and welcome to Verdictum. I'm Sheetal June, and in today's episode we will talk about a new ruling regarding award of compensation in accidents of two-wheeler vehicles where the rider doesn't wear protection gears. It has been the practice that if a motorcyclist was involved in an accident and was not wearing a helmet, many insurance companies would lower the value of the claim and then argue that the reduction was due to the rider not wearing a helmet. However, they have to discontinue this practice from now on. A recent Karnataka High Court ruling has stated that while not wearing a helmet is a violation of the law, it does not automatically disqualify someone from receiving compensation. A division bench of Justice K. Somashekar and Justice Chilakur Sumalatha observed that though the failure to wear protective headgear constitutes contributory negligence, it should not drastically affect the compensation awarded to the claimant. It's fair to conclude that while the failure to wear protective headgear, as required by Section 129A, constitutes contributory negligence, it should not drastically affect the compensation awarded to the claimant. The principle of just compensation necessitates the courts award damages that are fair and equitable, considering all circumstances without unduly penalizing the claimant for not wearing a helmet. The primary focus remains on ensuring that the victim receives adequate compensation for their injuries and losses, the court said. The court added that the contributory negligence arises when the injured party's negligence contributes to the harm they suffered, and in the context of motor vehicle accidents, if a rider does not wear protective headgear as mandated, it could be argued that they contributed to the severity of their injuries, the court said. Moreover, under Section 129A, the offence of not wearing protective headgear attracts a fine of ₹1,000 or suspension of the driving license for 3 months. Given this relatively minor penalty, reducing the insurance claim amount by 10 to 15% due to non-wearing of protective headgear is unjust. The fine and suspension already address the non-compliance, making additional reductions in compensation disproportionate. The court also observed that the primary focus should remain on ensuring that victims receive adequate compensation for their injuries and losses. With this view, the court allowed the appeal filed by one Sadat Ali, who was involved in an accident on March 5, 2016 on Bengaluru-Mysuru road. His motorcycle was hit by a car from behind, due to which he sustained injuries on the head and other parts of the body. Khan had moved the Motor Accident Claims Tribunal for compensation, stating that he had spent ₹10 lakh towards his medical treatment and other incidental expenses. On September 24, 2020, the tribunal awarded ₹5.61 lakh as compensation while pointing out that the claimant was not wearing a helmet at the time of the accident. Challenging this order, Khan stated that he is involved in manufacturing of wooden toys and lost ₹35,000 per month that he used to earn. The division bench said that though the tribunal noted that claimant was not wearing a helmet and sustained injuries to vital parts of the body, still he is entitled for the compensation. Courts have established that the primary focus in determining compensation remains on assessing the respondent's negligence in causing the accident and the overall circumstances. While wearing a helmet is crucial for safety, it should not be the sole factor in reducing compensation. The court will evaluate the extent to which the claimant's failure to wear a helmet contributed to their injuries and may reduce compensation proportionally if contribution is found. The court concluded that the Motor Vehicle Act is a beneficial legislation and the entire liability should be fastened on the insurance company. Thank you for watching the video. Hope it was helpful. For more such informative content, subscribe to our channel and download the Verdictum app on iOS and Android devices.